Good morning, everyone.
Morning, Judge.
Morning, Your Honor.
Good morning. Can you hear me? Everyone hear me?
I can hear you, Judge.
Yes, ma'am.
Yes, Judge.
Okay. I'm not good at this video stuff, so I'm sorry. Or I can't get the video on, honestly. I don't know how.
Okay. This is 213858 LT. This is Van Buren Estates versus John and Jennifer Laidman.
Your Honor, for the record, Attorney Ian Morton, Appellate Law on behalf of Van Buren Estates.
Ma'am, state your name for me, please.
Oh, I'm Jennifer Lademan.
Today's the day and time set for hearing on defendant's motion to set aside default judgment. The reason the court has received and reviewed the motion filed by the defendants along with the response submitted by the plaintiff's office. And just so the parties are clear, the court asked the civil department to schedule this matter for hearing for two reasons. First, the defendants were alleging that payment had been made in full for the past due rent. And secondly, a second case was filed, 220055 LT, was filed during the Sarah stay in the case that was scheduled for today, the 213858 LT. And there was a request, an application in order for eviction in the 3858 case. And the court just wanted to be sure that everything was clear between these two cases and the parties were on the same page regarding the status of the non-payment of rent cases. And understand that the 220055 case has been dismissed. And in reading the plaintiff's response to defendant's motion, it appears that plaintiff is no longer seeking an order of eviction, correct, Mr. Morton?
That is correct, Your Honor. The payment was received on March 7th. Was it to be able to bring the balance current? And in fact, right now, there's a $1,472.64 credit, which was not in place at the time that the judgment was taken, but is in place at this time. So again, Your Honor, was it at this time, and as the court stated, there was an inadvertent additional judgment case that was filed, but that was dismissed. Was it with these long Sarah stays, sometimes it's everybody learning to adapt, but that case was dismissed. We feel the judgment is valid, but again, but it's moot now because the payment has been received and no further action will be taken on it.
Ma'am, where is John Laidman?
He is in the other room. Want me to get him?
Okay,
I'm afraid to move my phone. Do you need him here?
not really. Today's the day and time scheduled for hearing on your motion. Your motion to set aside the default judgment is going to be denied. As Mr. Morton indicated in his response, there was not a valid, the motion did not contain all that it should contain to set forth good cause for failing to appear or meritorious defense to the facts at issue. The court took it more as a request to stay the writ than a motion to set aside default judgment, if that makes sense to you, ma'am.
It does not. I'm sorry. I don't understand that kind of the lawyer talking stuff.
I understand that, ma'am. Here, the fact is that you and Mr. Laidman failed to appear on February 16, 2022. When you filed the motion to set aside default judgment, you had to give the court a good reason why you weren't here on February 16th, along with a defense to the underlying case. And you were not, there is nothing in your motion to set aside default judgment that indicates that you did not owe rent at the February 16th hearing. The issue was the Sarah funding.
Right. I understand that part.
Okay.
I never received a
So-
notice to appear that day, though. I thought I was still had the 45-day stay from the other case. I didn't know about this case till I got the default paper in the mail, the 213858.
Oh, God.
That's I actually had
This
to call.
case,
Okay.
this case, ma'am, was served by posting at the property back on September 10th.
September. Right.
Yes.
I figured that out when I talked to Sandy, but, again, I thought I was under the 45-day stay from the 220055 case. So when I got the default thing in the mail, I was confused. That's why I had to call the courts to find out why there was two different case numbers. And,
It was two, ma'am, it was two different case numbers because it was two different cases. But the court has reviewed both of the files. They're traveling together. The matter has been resolved in its entirety, and Mr. Morton has actually indicated that there is a credit on the account after the application of the Sarah payments, correct, Mr. Morton?
That is correct, Your Honor. For the record, again, it's $1,472.64 after the application of the funds that were received on March 7th.
okay,
Understood,
so,
Ms. Lakeman?
okay, I get that now. Okay, I'm sorry. Yeah.
That's okay. What you wanted to do in filing the motion has been accomplished. There is no writ. Mr. Morton has acknowledged the credit. Is there anything else, Ms. Lakeman?
Oh, okay, so we're good? Everything's paid and?
Yes, ma'am.
I'm not- Okay, thank you. Okay, I misunderstood something that was said and I thought I was still getting evicted somehow, so I apologize for
ma'am.
that all along.
You're not. The
I'm about to
plaintiff
start
has
crying, so
indicated
I'm
that
sorry.
they're withdrawing their application for eviction. The court's already X through it. We're fine.
Thank you so much. I didn't
Have a
understand. and I
wonderful day,
apologize.
ma'am.
You too. Thank you so much.
Thank you.
Both of you. Thank you.
Good luck, ma'am.
Thanks.
Thank you, Your Honor. I'll
This
be
is
back
the-
I'll be back at 10 o'clock. Was it? Thank you.
That's it? Okay.
That's only one for 9. I'm back in the 10 o'clock docket. In the meantime, I'll go talk to the mediators. Thank you.
Thank you, sir. This is
Thank you.
213790 LT. This is Park Estates versus Steve Mealy.
Get out of here.
Good morning, Your Honor. Jenny Scheid on behalf of the plaintiff.
Good morning, Ms. Scheid. The court received this morning a proposed stipulated order adjourning hearing. The civil
Yes.
department this morning is short-staffed and my office is short-staffed. And the stipulation that was submitted by the parties does not contain a specific date. And rather than have Sandy continue to answer the phone and intercept the email, bring it up, the court just requested that somebody come on so I can give you the date for the adjourned motion. That date will be May the 4th, 2022 at 10 a.m. That's back in courtroom number 1. They will mail out a new notice. If someone comes on from the Civil Criminal Litigation Clinic, the court will advise them of that as well. But the court just wanted to give you a good date for that adjournment on that matter.
Thank you, Your Honor.
And your other matters are not scheduled until 10 o'clock?
Your Honor, I have that we have 2 of them scheduled for 9. They were originally assigned to Judge Brooks Green, but they were changed over to you. One is Park Estates versus Daphne Rice and William Wells. The other is Metro Commons versus Taurus Holland.
Neither of those are in the stack or on the list of files that I have. Would you give me the case numbers, please?
Yes, so the first one I mentioned, the Park Estates is 214422.
Okay,
And the second one, this is the Holland case, is 220667.
the 214422 case is actually March 30th.
Okay,
And 220667 is also March 30th.
okay, that explains it then, Your Honor.
Okay.
My apologies, and thank you for your assistance
No
on that. We
worries.
will be back at 10 o'clock.
I'll see you at 10. Thank you, ma'am.
Thank you.
Mr. Graffin Reed,
Yes.
please turn your video on.
Okay.
Good morning, Ms. McLemore.
Good morning, Your Honor. Danette McLemore appearing on behalf of the defendant in this matter, Your Honor.
This is 214-827 LT Southport Apartments versus DeGraffin Reed. Thank you, ma'am.
Richard
Would you like
Herman.
to speak to?
Sorry,
Mr.
Judge.
Herman, good morning. I'm sorry. Would you like to
No
speak
worries.
to Mr. Herman this morning in a breakout room?
Yes, I would, if that's okay with Mr. Herman.
Of course.
Trying to send
Thank you,
you
Your Honor.
into.
I only talk to
breakout
nice
room.
people, so why wouldn't I?
Ms. McLemore, do you want your client to come as well?
Sure.
Good morning, sir.
Good morning. How are you this morning?
I'm wonderful. How are you?
I'm well, thank you.
I think you might be in the wrong place.
I'm here on Denise Howder. It was scheduled for, I was at the mediation a couple weeks ago and they put it up for today. I can give you a case number if that's helpful.
Would you please?
Yeah, it's 220615.
I'm looking at the ROA right now and no one appeared for the hearing. It appears that a dismissal for non-service was entered on March the 21st. Do you have an actual notice to appear with me this morning?
I was out of town last week, so when we were at the mediation, I let the mediator know that, so they scheduled it for today. And I haven't been into my actual office to see if there'd been any notices because I just got back.
I see the ROA and it doesn't appear that it was scheduled this morning. I don't have that file number. And I was looking to see if there were other. It appears that the matter was dismissed. The court's ROA is available online if you want to take a look. It's
I just pulled it up. Yeah, I just pulled it up. Why? And it was dismissed because we didn't appear last week? Dismissal for non-service.
Not last week, didn't appear at the, oh, that was last week. I'm sorry. March 16th. That feels like a lot more than a week ago. No one appeared for hearing on March 16th.
Oh, that's odd all right. Who should I get in contact with? Because we didn't want it dismissed. I was on vacation and that's why it was, and I let the mediator know that the week prior when we were there for the mediation.
You let the mediator know at the March 9th hearing?
Yeah, because we were going to schedule it for last week. I said, I was going to be out of town on a family vacation, so I needed it scheduled. So that's why I have today's date while I'm here.
You would contact the civil department and as I indicated, they are a little short-staffed today. But if you just looking in the file, if you would give me some time at the end of the docket, I'll go down and talk to the civil department about, and I'll have her pull the file. If you want to send a. I'm only chatting with you because no one else was ready, but if you want to contact the civil department, that's fine. But like I said, she's a little short staffed. I'll talk to her at about 10:30 when I'm done with this docket this morning.
Okay, I'll call after 10:30, after 11 o'clock then, after we get a chance to speak
Thank
with her.
you.
I'll get it figured out. Thank you, Judge. I appreciate it.
Have a good day, sir.
Thank you.
Judge,
Sir,
I don't know if my worthy opponent is back on. I can't, I'm doing this on my phone. It's really hard for me
she's
to.
back and I'm trying to pull her client back out. Here
Okay,
she is.
perfect.
So we have agreed that we like to get an additional adjournment in this matter because there is a recertification pending. So if we have a date, perhaps in 3 weeks, if Your Honor is so inclined to adjourn it for another 3 weeks.
And Judge, as I have indicated to counsel, I'm willing to do that. I don't want to lose Mr. DeGraffin Reed, sorry, as a tenant, and I'm sure she doesn't want to lose us. But this is I'm going to request a judgment the next time we come up if it hasn't been paid by then. So I just try straight up. I'm willing to
I
do this.
understand. There's two things, Mr. Herman and Ms. McLemore. You can go on with the regular civil docket on April the 5th, which is not 3 weeks. And then this court's next availability would be May the 4th. Because of how we schedule the landlord tenant cases.
Okay.
What is this date? I'm sorry. This is 3/23.
So May 5th would not be 2 weeks.
No, April.
I mean, April 5th would not be 2 weeks, and the other one would be almost 5 weeks.
Is there another way, Judge, to get on the general docket after April 5th, but before May, whatever that was? I'm trying. I'm trying
No,
to get
Mr. Herman,
right.
you're fine. Stop talking for 1 second. Let me go grab some calendars. Hold on.
Okay, thanks, Judge.
So 3 weeks will put us. What is April 12th, maybe? Mr. Herman,
Yes,
your availability for April 12th?
I will make myself available, Judge.
That would be a good day for me, Your Honor.
I just want to make sure that's. Well, that might work. April 12th at 9 a.m.
Perfect.
Thank you, Your Honor.
April 12th, 2022 at 9 a.m. Back virtual courtroom with me. I have sentencings that morning, but I should be done by that point, and I have arraignments that day. But I can't imagine that we wouldn't start at 9 in this matter. Anything else, Mr. Herman?
No, I'm just hoping that it gets paid and I can dismiss it.
That would
So-
be
Anything else,
great.
Ms. McLemore?
No,
Thanks,
that's
Ms.
all, Your Honor.
Thanks, Miss McLemore.
Thank you.
Thank you.
Judge-
Thank you, Mr. Herman.
Referee,
Thank
I'll
you,
see you
Judge.
back here on April the 12th, ma'am. Have a good day.
Thank you, Your Honor.
Okay.
So Judge, I do have one more. I'm not sure what time it is, to be honest. Let's see, it's
It
9:20.
is. It's right now with Ms. McLemore again. Give me 1 second. I know Mr. I saw Mr. Robinson here.
Morning, Judge.
How are you, sir?
Well, thank you.
Let me dispense with Mr. Herman and Ms. McLemore's other case, and then I'll get to you, Mr. Robinson. This is 214829 LT, Southport Apartments versus Vina Lawrence.
Richard Herman plaintiff.
Wait, Ms. McLemore left. I'm bringing her back in.
I don't think I asked her if that was her.
What was
Ms.
the other
McLemore,
case?
it's Vina Lawrence, Kvina Lawrence. I have you noted as the attorney of record.
Okay, I don't have that on I didn't have that on my calendar, Your Honor. I guess could I speak to Mr. Herman about that? He did ask me
Oh.
about that, but I don't have that on my
Well,
calendar.
You were here on November 24th and a Sarah stay went into place, but when the request to set aside the Sarah stay on February 9th, you were not here. You can go back to that same room with Mr. Herman. Let me get you back in the Herman's meeting room. Here you are. Mr. Robinson, 220459 LT, Evergreen Town Country versus Justin Langlos.
Morning, Your Honor. Excuse me. For the record, Steve Robinson appearing on behalf of Evergreen Town and Country.
Mr. Robinson, today is a date for the second hearing in this matter. The first hearing was on February 23rd, 2022. The matter was scheduled for 9 o'clock this morning. It's now 9:23 by the court's clock. Do you have any information regarding the status of this matter?
The only information I have is that he hasn't paid his rent, but other than that, no. I haven't had any contact.
Thank you. Scheduled for 9 o'clock is now 9:23 by the court's clock. Defendant has failed to appear. How do you wish to proceed, sir?
Your Honor, I'm requesting a default judgment.
Was he at the first hearing?
I don't believe he was, Judge.
Defendant has failed to appear for this hearing as indicated by Mr. Robinson. Default judgment shall enter in favor of plaintiff and against defendant. The past due rent,
$2,261.76. Court costs of $168 for a total, if my math is correct, of $2429.76.
past due rent, $2,261.76, $168 in court costs for a total of $2,429.76. Plaintiff to submit that default judgment. Anything else in this matter, Mr. Robinson?
No, Your Honor, I believe I have a 10 o'clock with you. So
I'll see you at 10, sir.
thank you, Judge.
Thank you. Julie J. May I have your last name, please?
Jones?
Ms. Jones, this matter is actually scheduled on March the 30th. Did you receive
Oh.
a notice that it was this morning?
I was on for 2 weeks ago and they told me, I'm sorry, today at 9 a.m.
Do you have your notice with you this morning?
No, I do not.
Okay, I want to make sure that we're looking at the right case number. Is this, oh, no, let's back up. This is Huron Estates versus Julie Jones.
Yes, ma'am.
Ma'am, that matter is actually scheduled for March the 30th at 9 a.m.
March 30th. Okay, I had wrote down the 23rd. I apologize.
Don't apologize, ma'am. It's fine. I'm not sure. Oh, Ms. Jones, it actually gets better. Your landlord is dismissing this case.
Oh, hooray. Okay, I just
They
spoke to them
filed-
Friday.
They
And they
filed a
said,
dismissal this morning. That's why I knew that it wasn't scheduled for today because they already called me about it.
okay, so I don't have to appear on the 30th then?
Correct. You should be getting a copy of the dismissal in the next couple of days.
Oh, hooray. Okay, thank you.
Have a good day.
Also, thank you. Bye.
Thanks.
How do I hang it
I'll
up?
push, you're good.
Okay, thank you.
Judge,
Yes, sir.
sorry, am I interrupting you?
No, Ms.
So,
McLemore's not back yet.
no, she froze on me and then she disappeared. So I don't really know where she is.
I'm hoping that
Hello?
she'll log back on like she did before. Yes, ma'am.
Hi, this is Patricia Agarwal.
Ma'am, I think, hold on one second.
We've been having a hard time getting in.
I'm not sure what's going on. The attorney was already here this morning. This case was dismissed for lack of service, but there appears to be an issue. Did you receive a notice to log on this morning to this courtroom?
No, what we got was when I saw the last person, judge, she told me a date and time and we didn't get any paperwork for it. And I wasn't in a position to write it down, so I just had a feeling
Ma'am,
today.
are
and we-
you on a phone or on a tablet of some sort?
I'm on a phone.
I'm sorry?
A phone.
Okay. Here's the issue. The matter is not actually scheduled for today. The case has been dismissed.
Okay.
Did you
The
appear
eviction
at
has?
the, did you appear at the hearing on March the 9th or March the 16th?
No, we appeared at the only one that I had notice of was, let me see what date is on here. Where's our court date?
Last week, ma'am, or 2 weeks ago?
I think it was 2 weeks ago. They told us.
Okay.
Go ahead.
I was gonna say, there's a problem with this case. It's not on my docket for today. It was actually dismissed 2 days ago, but the attorney appeared as well. There seems to be some miscommunication regarding the date of this. I want to follow up with our civil department, but I can't do it right now. I'm in the middle of some other cases.
Okay, so,
So
No.
yeah, like basically now what, because I'm disabled and I'm sick and I'm really trying to find a place to go and I can't be tossed out right at this moment, I'm trying to get help.
I understand that, ma'am, but the plaintiff's attorney is not here and it's not on the docket for today. So there's nothing that this court can do right this second in this matter. The case has been dismissed.
Okay, well, when will we be notified on the matter, if it has to do with my living situation?
Ma'am, I understand, but there's nothing for me to do. The case has been dismissed. That means there's no case pending in the court right now.
Oh, so
So your mom
the
didn't-
lawyer and my mom went up there for nothing. And
I'm
Because-
sorry.
the miscommunication.
All right, thank you, ma'am.
You're welcome. Have a good day.
Thank you. Bye-bye.
That's what she said.
So Judge, I do not see Ms. McLemore anywhere. I
She
went
hasn't-
back.
She hasn't come back.
So the situation is that with this case, the Lawrence case, Ms. McLemore indicates to me that she didn't receive a notice of hearing on this case. I don't know. I received one, and
Is she in this? Well, here's the question. Is she indicating to you that she's representing? the
well, she
tenant?
went online and she came back and said that with regard to her, the matter was closed. I don't know what that means. You know, is she no longer representing Ms. Lawrence or Mr. Lawrence, whatever, I guess Ms. Lawrence? I don't know. I do know that the 45 days expired, I think you said, to your point, Judge, in February, and you adjourned it. I'm not remembering why you adjourned it. I may not even have been the attorney handling it in February. But-
You were the attorney handling it in February. The defendant appeared and Ms. McLemore didn't. And when I asked the defendant if they were represented by Ms. McLemore, I must not have gotten a clear answer because my notes say attorney not online. I adjourned the matter for her to appear and make sure that the civil department sent notice. There is a notice in this file dated February 14, 2022, indicating that service was made upon Ms. McLemore, 32 Market Street, Suite 2 in Mount Clemens. She came on this morning, she left. It clearly was not on her docket of things to do, cases to handle, not things to do, cases to handle. But in any event, this matter has now been pending since October 25th, 2021. There's never been an answered file. There's not a formal dispute regarding the rent that's due in this matter. The Sarah stay went into place originally on November 24th. Plaintiff requested the lift of the stay on January 12th. Matter was scheduled on February 9th. You're here. The defendant has failed to appear at all this morning, sir. How would you like to proceed?
Well, I hate to do this to Ms. McLemore, but I really do need to take a default judgment. So I guess I'm going to request that. And if she reappears, Judge, if you would ask her to give me a call, I would appreciate that, and I can explain to her. And I guess what we can do also is give her client a few extra days to see what's going on with her life, and that might help.
The
So
rent to retain possession, sir?
3040.42, $154 in court costs, totaling $3,194.42. And why don't we give her until April 10th, 2022. That gives her an extra week beyond the statutory time. And that should give her Ms. McLemore, enough time to do whatever it is she needs to do.
Just so we're clear, this court is going to enter a default in this matter for the reasons previously stated. Also, that Ms. McLemore was here this morning, did not have this case on her docket, somehow left the breakout room. The court called another matter to allow Ms. McLemore time to reappear and indicate more definitively whether or not she was representing tenant Lawrence in this matter. She has not reappeared. There is no one in the court's virtual waiting room. Plaintiff will submit a default judgment with rent to retain of $3,040.42, $154 in court costs, total $3,194.42 with a pay or move date of April 10th, 2022. Anything else, Mr. Herman?
Just one thing, Judge. Would you happen to have in your file a number for Ms. McLemore?
I have 248-443-8068. And that's on her appearance form.
No extension?
No, sir, they didn't include it.
Okay, I will try to give her a call and explain to her what happened. I just don't want her to think that, whatever. And,
If
okay,
if your conversation with her yields a different result requested by the parties, just let Sandy know and she'll pull the file and get it back up to me.
no problem.
Thank you, sir.
Thank you, Judge. Have a great day.
You too.
Yep.
Good morning. This is on Park Estates versus Neely.
Good morning. Yes, Your Honor.
Good morning, ma'am. I called the case earlier because there was a stipulation to receive to adjourn this case with a date that had not been approved by the court. And because the civil department is short-staffed this morning, rather than have the parties go back and forth with them, plaintiff's attorney came on this morning and I gave a new date of May the 4th at 10 a.m.
Okay, great. Thank you so much, Your Honor. Appreciate it.
Anything else this morning, ma'am?
No, I believe that's all. Thank you so much.
Anything else, Ms. Friedman?
No, that's it. Thank you so much, Your Honor. We appreciate your time.
Thank you. Have a good day.
You too.
Bye-bye.
Okay. I gotta jump back and forth. Thanks.
Good morning, all. This is Judge Martin. This is courtroom number 1. Today is the day and time set for hearing in landlord-tenant matters. If you're not scheduled with Judge Martin or you do not have a landlord-tenant matter, you are in the wrong courtroom. Please check your notice. Mr. Morton and Mr. Morton, do you need to speak regarding the Saracen matter?
Which matter, Your Honor?
I don't believe.
Oh, I'm sorry, that's Ms. Scheid.
Okay.
If I could speak with Ms. Scheid on the Saracen matter, I would appreciate that.
Hold on one second. I thought I saw her here. Yep, she's here. Morton, if you will go into, let me put you where you're supposed to be. Levine, meeting room. Ms. McLemore.
Yes, my internet went out.
Oh, no, on the Lawrence matter.
Yes.
Are you representing? They're here now. Lawrence is here. They just come. Hold on one second. Let me bring them in. Their audio's not connected.
I apologize, Your Honor. I was looking up the case and my internet just went out, and now I'm trying to do this Zoom on my phone, and I'm not real familiar with doing that.
That's okay. We'll see if we can get it worked out. Lawrence.
Yes, I'm here.
This is 214-829 LT. This is Southport Apartments versus Lawrence. Ms. McLemore, we called this case earlier and you had a loss in technology. Hold on one second. I don't know what's going on here. There we are. That's better.
Right.
You had a loss in technology. The court wasn't clear if you were representing the tenant in this matter or not.
We do. We had a file with with Ms. Lawrence, and Your Honor, I was not aware that there was a hearing scheduled today. Mr. Lawrence, when I spoke to Mr. Herman in the breakout room, we were looking the case up online. I was looking it up, and then my internet just went out, so I lost all connection. Your Honor, I don't know if Mr. Herman is still here, but can you tell me, was there any resolution with this?
Ma'am, based on the failure to reappear, the court was going to grant default in this matter. Mr. Herman asked that you give him a call. He is not here and he does not have a 10 o'clock docket. I will hold the file, and I told him I would do that. Told him that if you came back on and confirmed your appearance in this matter, the court would not enter that default. Do you have his number? Would you like the court to give it to you?
I have it, but I can't look it up right now. So yes, if you could give it to me.
If you're ready,
Yes.
it's 248
Okay.
593
Okay.
0395.
0395 593 0395, and that was 248. And Your Honor, again, not exactly sure what happened because I did file an appearance in this case, but I don't recall, it wasn't on my calendar, and I did not recall getting a notice to appear. I called my office a few moments ago, and there may have been a notice to appear that was sent, but it never got on, unfortunately, didn't get on my calendar. And I had not spoken with the defendant in this matter. Is it possible to adjourn this matter for 1 week?
Well, you have not spoken to
Opposing
Lawrence
counsel,
in
I
this
will call
matter?
him first.
Would you do me the favor of going into a breakout room and speaking with your client? I will likely adjourn this matter to the other date, that April 12th date. But in addition to going to the breakout room and speaking with your client, I would ask you to follow up with Mr. Herman, okay?
Yes. Thank you, Your
Let me
Honor.
give me 1 second.
Thank you.
You're welcome. Okay. Oh, Mr. Morton. The correct Mr. Morton this time. Good morning, Mr. Horka.
Good morning, Your Honor.
How are you, sir?
No complaints. How about yourself?
I'm good. It's been a while.
Hopefully that means I'm staying out of trouble.
Let's see who this is. Mr. Stanford,
Yes.
what are you here for, sir?
Well, against Horka for 49066 Tagati Pass Street.
Have you retained an attorney, sir?
No.
Okay. This is 220223 LT. This is Walter Sikowski versus all occupants at 49066 Tagati Pass.
Good morning, Joe Horka, P75969, attorney for the plaintiff.
Mr. Stanford, please turn your video on and state your name for the record.
Salahuddin Stanford.
Thank you. The last time we were here, the court granted an adjournment based on Mr. Stanford's appearance and his request for an adjournment to retain an attorney. Today is the day and time set for hearing in this matter. How are we proceeding?
I also adjourned it because I filed a petition that's been submitted and been approved. So at this point in time, I challenged Walter's position as the rep. And at this point in time, since I challenged it, he can't do nothing with the estate. It's in the court. He can look at it, my court view. And I sent the mail out to Walter's business in Middlebelt, off of Middlebelt, through the mail.
Mr. Horka?
Your Honor, I requested not once, but twice from Mr. Stanford to send any petitions, anything he's trying to present to the court to my office so I could review it and discuss with my client. I've received nothing.
It got approved on the 18th, and I sent it out on the 18th.
What was approved on the 18th, sir?
The petition to exclude Walter as my personal rep.
Mr. Stanford, the issue is, the last time we were here, you provided information to Mr. Horka and you were supposed to stay in communication with him or have your attorney do it. I thought you're indicating that your attorney was going to be Arthur Grant. The court hasn't received an appearance from Mr. Grant.
Yes,
But
he
in
did
any
not.
event, this,
Oh, go ahead, my bad.
you go ahead.
I was just saying that he said he wouldn't take it. He wouldn't take the job.
This court has not received an appearance from any attorney. This court has not received any document to suggest that the named plaintiff is not able to proceed this morning. That being the case, Mr. Horka, how would you like to proceed, sir?
Should ask for a judgment by hearing with 10 days to vacate.
Mr. Stanford, raise your right hand for me, please, sir. Do you swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. Mr. Stanford, do you acknowledge that you received a letter of authority from the personal representative, Mr. Walter Sikowski, back in February 2021?
Yes.
Sir, do you acknowledge that you received a notice to quit back in September 2021, indicating you were to vacate these premises based on the termination of tenancy and for non-payment of rent, that you had until October 27th, 2021 to move?
Yes, non-payment of rent. It was no rental agreement.
But that's what the notice provided, correct, sir?
Yes, but I have no rental agreement, so how can I pay rent if there's no rental agreement?
It was a termination of tenancy indicated on that notice to quit as well, correct, sir?
I believe so, but they said the reason was for non-payments. I'm willing to pay for where I live.
Mr. Stanford, have you filed a answer or response to the complaint received in this matter?
I don't understand the question.
Have you filed any documents in this court regarding the complaint to recover possession of property that was served upon you back in December of 2021?
Well, if I understand the question, no, but I filed a petition to have them removed.
Did you file anything in this court, in the 34th District Court?
No.
What is your defense to the complaint for recovery, possession of property in this court scheduled for this morning?
Since I filed a petition against him by Michigan law, he can't proceed with anything with the estate unless because he's technically not the personal rep right now since he's been challenged. Once you've been challenged for the personal rep, they have to have a court date for basically who's going to be the rep. And since he's the rep trying to kick me out for the estate, that's what he's trying to do right now. I challenge that, so he can't do that right now. He probably can do it at a later
Sir,
date.
do you have an order from a court of higher jurisdiction invalidating Walter Sikowski's right to represent the estate in this matter?
If you can look up on my court view, just by my name, it's like a petition that says excluding him for being the rep. So I'm saying me challenging it.
My question to you, Mr. Stanford, is do you have an order from a court of higher jurisdiction?
I'm not understanding the question.
Mr. Horka, the court will grant judgment in favor of plaintiff and against defendant, 10 days to vacate the premises. The court has not received any document from either the defendant or a court of higher jurisdiction indicating that the plaintiff listed on the complaint is not the appropriate plaintiff to proceed in this matter.
Thank you, Your Honor.
Anything else, Mr. Horka?
Not at this time.
Anything else, Mr. Stanford?
So basically, I got to send you the information. So where do I got to send the information to?
Mr. Stanford, you should send it to Mr. Horka. And you can go to the court's website and there's the ability to upload documents that you want to attach to this file, but judgment will enter. That concludes this matter. Have a good day. Ms. McLemore, you're back with your client?
Yes, I am. And I will give Mr. Herman a call. But again, I just wanted to confirm that date, April the 12th is that at 9 o'clock?
9 o'clock. I'll have it travel with those other files so we can dispose of them at the same time.
Thank you so much. Thank you so much, Your Honor.
You're so welcome, Ms. McLemore. You have a wonderful day.
You too. Thank you.
Thank
Judge,
you.
Judge, Ms. Scheid is having a difficulty coming back into the court.
She's here.
I'm right here.
Okay, great.
Thank you for helping her though, sir. I don't see what happened to Mr. What happened to Mr. Morton? He's back. Okay. Are we ready to proceed on Sarazen?
Your Honor, could I just speak with Ms. Scheid again briefly? We had a timer on the breakout room and I was talking to my client and it just didn't work out.
You can go right back to that same room. Mr. Robinson.
Good morning again, Judge.
This is 220216 LT. This is Royal Village versus Kevin Samerzik. Today's the day and time set for this, looks like third hearing in this matter. This is a termination of tenancy scheduled this morning at 10 a.m. It is now 10:14 by the court's clock. Mr. Robinson, you're aware of this court's policy. It's 15 minutes after the scheduled start time. I believe we're close enough. How are we proceeding this morning in this matter?
I don't believe Mr. Zamarchik is present. I asked the court for default judgment.
Again, this matter being scheduled for 10 a.m. It's now 10:15 a.m. by the court's clock. Defendant having failed to appear, default judgment shall enter in favor of plaintiff and against defendant. Plaintiff's office will submit judgment for entry. Anything else, Mr. Robinson?
Nope, I believe that's all I have with you this morning. Thank you, Judge.
That is, sir. Have a great day.
You too. Take care.
Ms. Thornsberry, wait. Were you trying to get his attention?
Oh, sorry. I was saying thanks, Judge.
You're welcome, ma'am. Good to see you.
Sorry. Thank
care.
you.
That's okay. Mr. Morton, this is 213386 LT. This is GI&I versus Kalia Allen. Kalia Allen. Today is the day and time set for hearing in this matter. It was scheduled at 10 a.m. It's now 10:15 a.m. by the court's clock. Defendant has failed to appear. Parties were last here on February 9, 2022. There was some conversation that a check had been issued, but there was a balance due and owing. The parties asked for an adjournment. There was a recertification request pending. Mr. Morton, what's the status of this matter?
Your Honor, as of today's date, there has been what appears to be, and what my client is understanding, has been two payments of large amounts likely distributed by Sarah. However, even after those payments, rents retained are $5,089, core costs of $167, for a total of $5,256. The most recent payment was received back on 2/10 of $5,690. But since that date, which was about looked like it was a day after the last hearing time period, no other funds have been paid. And then even after that payment in the month of February, there were still over $3,700 past due. So based on that, we'd ask that a default judgment for possession be entered. I believe this case was filed by my office back in July.
Thank you, Mr. Morton. This court shows that the summons and complaint was actually filed on August 3rd, 2021. When the parties were here on February 9th, there was an indication that the $5,690 check had been issued on January 8th. Why it took another month to reach your client? It's another conversation for another day. This matter was scheduled for 10 o'clock. It's 10:17 by this court's clock. Defendant has failed to appear. There is no one in this court's virtual waiting room. Default judgment shall enter in favor of plaintiff and against defendant with writ to retain of $5,089, $167 in costs, for a total of $5,256. Plaintiff's office will submit that default judgment to the court. This is 215649 LT. This is Van Buren Estates versus Deborah Copley, Koepfle. This matter was also scheduled at 10 a.m. Last time the parties were here was January 5th, 2022, which time a Sarah stay went into effect.
If I may, Your Honor.
Yes, please, sir.
Your Honor, was it, we're moving to dismiss this matter without prejudice. Payment had been received.
Oh, okay. Plan to submit dismissal to the civil department. Mr. Morton, I think that's the last case that I have for you this morning, unless you show something else.
Nope, those were the only two matters. It was a rather light docket for me in front of you, so hopefully makes your day a little better.
Have a good day, sir. Thank you.
Thank you.
This is 215532 LT. This is Huron Estates versus Holly Agee.
Jenny Scheid on behalf of the plaintiff.
Matter scheduled at 10 o'clock is now 10:22 by the court's clock. The defendant has failed to appear. Ma'am, how are we proceeding this morning?
Yes, we'd like to request a default judgment against the defendant for failing to appear at today's hearing. I just wanted to confirm with the manager about whether or not this includes April rent, because the amounts that I was given for another case did include. So Robert, can you confirm that Aggie owes $3,306.07 for an unpaid rent?
Okay, 3,000. Hold on just a second. I show her owing, including legal fees at $34,707.
Okay. So we're going to do a quick calculation. So Your Honor, the resident owes $3,305.54 in unpaid rent. There's $164.53 in court costs for a total of $3,470.07.
Based on the defendant's failure to appear this morning, default judgment shall enter in favor of plaintiff and against defendant with rent to retain possession of $3,305.54. There have been $164.53 in court costs for a total of $3,470.07. Plan to submit that default judgment. Anything
Will do,
else in
Your
this
Honor.
matter, ma'am?
No, Your Honor.
Thank you. This is 215525 LT, Huron Estates versus Robert Sarrazin. Your appearances, please.
Jenny Shine on behalf of the plaintiff.
Adam Morton, P85423 on behalf of Mr. Sarrazin.
Last time that we were here was March 1st. There was an issue of the recertification, the Sarah recertification pending. How are we proceeding this morning?
Your Honor, it looks like we're trying to work out an agreement where Mr. Sarrazin would pay off the balance by the end of March. However, again, our numbers had included April rent, which was premature. So Mr. Morton was confirming with his client that he could pay the balance by the end of March.
Mr. Sarrazin, it is your impression today that you would be able to pay that balance, correct?
Yes, minus the Sarah.
Yes.
Did I unmute?
Yep, you unmuted.
Okay.
Were the parties going to do a conditional dismissal or consent judgment?
So does he have the Sarah check in hand?
He does not
No.
have the Sarah checks in hand. They should both be in the mail. I'm going to follow up with the director of Wayne Metro to try to get those checks either reissued and expedited. We have had success with that in the past.
Okay. So, Your Honor, at this point, we don't have the ceremony applied to the amount. And so Mr. Sarrazin is going to owe the entire judgment that we are seeking, and he would have to pay that if we get a judgment by April 4th, 2022.
I guess that doesn't answer my question. If you were in conversation and that there's this ceremony outstanding and understanding that Mr. Sarrazin will pay a part of the unpaid rent, were you considering a consent judgment, a conditional dismissal, or do the parties want adjournment to try to hammer out and locate and have the checks reissued, or what is
We
it
can
we
do a
wanna do this
conditional
morning?
dismissal as long as Mr. Sarrazin can pay whatever Sarah does not pay. And Mr. Sarrazin, could you please mute your background? I'm sorry, I'm having some difficulty hearing the judge with whatever it is that you have in the background.
Sorry.
Thank you.
Sir. Mr. Morton,
Yes, Your Honor.
how do you wish to proceed this morning, sir?
If they're willing to do a conditional dismissal, we can do a conditional dismissal, Your Honor.
Mr. Morton, can you forward over to me his, either the conditional dismissal itself or his settlement amount so that I can prepare the conditional dismissal?
Yeah, I can do that for you.
Okay, thank you.
I'll put a note in the file that the parties will be submitting a conditional dismissal. The civil department hasn't received something within 14 days. They'll put it on the no progress docket. Anything else on behalf of Huron Estates?
I don't think so.
Anything else, Mr. Morton?
Nothing further, Your Honor.
Thank you. We're all set. Mr. Sarrazin, good luck to you. That concludes this court's docket.
Thank
Everyone
you,
have a
Your
good
Honor.
afternoon.
Thank you.
Thank you.